Hello, everyone, and welcome to another episode of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 194 of the Forge of Freedom. Today, I've got a case. It's a Supreme Court case. It's actually it's interesting. It's from their so-called shadow docket, which we'll get into here in just a little bit. And it's not a Second Amendment case. It's not even a firearms case, but it is related or potentially impactful to those issues. And I want to say why. It's actually an immigration case, and it involves the ICE enforcement of immigration policies in California. The case is Noem versus Perdomo, and this case has the potential to have far-reaching impacts into many areas at the very heart of our freedom. And I think it could shape how government detains and questions people based on nothing more than mere probabilities and prejudices. If you're a regular listener to the podcast, you know we often explore how constitutional rights, like the right to keep and bear arms under the Second Amendment, get tested in courts. But this case, it's a stark reminder that the Supreme Court, when it loosens the reins on government power in one area, it can spill over into others, including the right to keep and bear arms. And so we'll unpack how this ruling issued on the court's shadow docket might pave the way for probabilistic policing, detaining people based not on what they've done, but because of what some percentage of people like them might do. And we'll tie it directly into concerns for gun owners, drawing on some insights from UC Law professor Rory Little, who sounded the alarm on this case in a recent SCOTUS blog piece, which I'll link to in the show notes. But before we jump in, just a quick note. This episode is about vigilance, and that's really what this podcast is all about, the Forge of Freedom. It's about forging freedom at the individual level. The idea is that our freedoms don't come from the top down. They don't come from government. They are forged through continued vigilance by the individual and by communities. So it's not forged in a vacuum. It's defended in the details of cases like this and through the individual actions of people like you. So if you're new to the podcast, tune in, because we'll talk about all sorts of issues that are related to that overarching theme. And if you're a returning listener, welcome back. I thank you for tuning in, continuing to tune in. So let's go ahead and dig into this Perdomo case. So Noem versus Perdomo, or more formally, Kristi Noem, Secretary of Homeland Security et al., versus Pedro Vazquez Perdomo et al., started in the heart of Southern California, specifically in 7 counties, including Los Angeles. A group of plaintiffs led by Pedro Vazquez Perdomo filed a lawsuit in the U.S. District Court for the Central District of California back in July of 2025. These folks weren't just random complainants. They were individuals who had been stopped and detained by Immigration and Customs Enforcement, ICE, officers, part of the Department of Homeland Security, based on what the court later called overly broad and discriminatory factors. And of course, ICE is an outgrowth of sort of post 9/11 Department of Homeland Security measures. What were those factors? So what were the reasons, what were the factors that these ICE agents were utilizing to stop and detain people? According to the district court's order, ICE agents were relying on a combination of 4 things to justify these detentive stops. That's legalese for stopping someone against their will and questioning them, even if briefly. The factors were, number 1, the person's apparent race or ethnicity, often meaning they looked Hispanic. Number 2, speaking Spanish or English with a Spanish accent. Number 3, being present at locations where undocumented immigrants are known to gather, like day labor pickup spots or parking lots. 4, working in specific jobs such as landscaping, construction, agriculture, or car wash car washes, industries that often hire day laborers without much paperwork. The plaintiffs argued this violated the Fourth Amendment, which protects against unreasonable searches and seizures. They said these stops weren't based on individualized suspicion, like seeing someone commit a crime or act suspiciously, but on generalized stereotypes. Imagine being pulled over or detained just because you were speaking Spanish at a bus stop or working a landscaping job. The district court agreed and issued an injunction on July 11th, 2025. So let's take a moment just for a brief explainer. First of all, what's an injunction? In simple terms, it's a court order that tells someone, usually the government or a company, to stop doing something. It's like a judicial cease and desist order. In this case, the injunction prohibited ICE from using those 4 factors alone or in combination to conduct stops in those 7 counties. It was a big win for the plaintiffs, effectively halting what they called roving patrols in urban areas far from the border. Because let's go back to those 4 factors again. The person's race or ethnicity, what language they were speaking, being present at certain locations like day labor pickup spots, or 4, working specific jobs like landscaping, construction, agriculture, car washes. All of these things are generalized categories of suspicion, not individualized suspicion, which we have historically required for stops pursuant to the Fourth Amendment. So the court in California, the federal district court, said, government, you can't do this. They issued an injunction saying the government can't stop or detain people based on these generalized factors. So after this injunction by the district court in California, the government, under Secretary Kristi Noem, didn't like that decision, so they appealed to the Ninth Circuit Court of Appeals, and crucially, and this is how it got to the Supreme Court, asked the Supreme Court for an emergency stay. A stay is basically the opposite of an injunction, or it stops the injunction. So it's a higher court order to pause or suspend the lower court's ruling while the appeal plays out. So here, the district court, the lowest level trial court, or the lowest level federal trial court, issues the injunction telling the government to stop. The government asks the Intermediate Court of Appeals, the Ninth Circuit, for an appeal, and meanwhile asks the Supreme Court, the highest level court in the country, for a stay, which means they ask the Supreme Court, to stop the injunction that was issued against them so that they can continue their enforcement based on these generalized factors while the appeal to the Ninth Circuit Court of Appeals is pending. So it's like hitting the pause button on the injunction so the government can continue operating as usual while the case plays out, because we know cases can take quite some time. So the stay application was filed on August 7th, 2025, and went to Justice Elena Kagan, who oversees emergency requests from the Ninth Circuit. She requested responses from the plaintiffs by August 12th, and after some back and forth, including amicus briefs from groups like the City of Los Angeles supporting the injunction and the Federation of American Immigration Reform supporting the government, the full court took it up. That is, the full Supreme Court. On September 8th, just a month later, the Supreme Court granted the stay by what appears to be a 6-3 vote. That means ICE can resume the stops pending the Ninth Circuit's decision and any potential certiorari petition, which is a petition for review by the Supreme Court on the merits of the case, the entirety of the case, not just the injunction. Kavanaugh wrote a concurring opinion explaining his vote, while Justice Sonia Sotomayor dissented, joined by Justices Kagan and Ketanji Brown Jackson. No one else wrote separately, which is typical for these sort of so-called shadow docket rulings. And we'll get to what that means here in just a bit. So you've got a basic understanding now about these terms like injunction and stay, but I want to talk a little bit about why they matter. As I said, the injunction stops the government's action, the government's use of these generalized factors for detention. A stay lifts that stop. allowing the action to continue during the appeal. But stays aren't handed out like candy. The Supreme Court has standards laid out in cases like Holder from 2009. And to get a stay, the applicant, here the government, must show, one, a fair prospect of success on the merits, meaning they're likely to win the full case eventually, and two, irreparable harm if the injunction stays in place, like national security risks or enforcement breakdowns. So why does this procedural stuff, why am I stopping to talk about these things? Why does it matter for liberty or for freedom? Well, it's because stays often decide the real world outcome. Once the Supreme Court green lights the government to resume its policy, the urgency fades and the appeal can drag on for years. So the government can continue to engage in their policy of carrying out these generalized suspicion stops, even as the case winds through the courts. It's a victory for expansive executive power and a loss for individual rights. And I'll just say here, it's rare that I agree with a decision of a court coming out of the Ninth Circuit or a California District Court, although there are some good judges there, but on balance, it's rare for me to agree with something out of the Ninth Circuit or California. But here, I think they got it right. So why do we obviously care about this if it's achieving something that many voters think is worthwhile, and that is deporting people who are in the country illegally? Well, it's because these sorts of actions could have far-reaching impacts, not just on the Hispanic community and illegal immigrants, but on each and every one of us. So let's talk a little bit more about the shadow docket. I mentioned it earlier, and this is a phrase coined by law professor William Bowdy in 2015. The term refers to the court's handling of emergency applications like stays without full briefs, oral arguments, or even explained opinions. These are supposed to be rare, but in recent years they've exploded. COVID vaccine mandates, abortion bans, election rules, you name it. Critics, including Justice Sotomayor in her dissent here, argue that it lets the court make major policy shifts in the shadows without transparency or accountability. No public hearings, no detailed reasoning from the majority, just a one-line order and maybe a concurrence or a dissent. In Perdomo, the shadow docket was in full effect. The court acted swiftly, but as we'll see, that speed isn't applied evenly across cases. Let's take a look for a moment at Justice Kavanaugh's concurrence, since it's the only insight we have into the majority's thinking. Again, there was no opinion here, just Justice Kavanaugh's concurrence in the outcome. He starts by citing the Immigration and Nationality Act, which lets officers interrogate any alien or person believed to be an alien about their right to be in the U.S. He references regulations allowing brief detentions based on reasonable suspicion of illegal presence, drawing from the 1975 case United States versus Brignani-Ponce. That case said Border Patrol could consider ethnicity as one factor for stops near the Mexican border, but not the only one. It had to be part of a totality of the circumstances analysis. Kavanaugh leans hard into the statistical analysis. He notes the government estimates 15 million people are in the U.S. illegally, with millions more in recent years. In the LA area, he says about 10% of the 20 million population, 2 million people, are undocumented. He argues this makes immigration enforcement especially pronounced there, justifying stops at day labor sites, car washes, etc. If someone's legal, they're going to be let go quickly. If not, removal proceedings start. Crucially, Kavanaugh says the district court's injunction was too broad. He cites City of Los Angeles versus Lyons from 1983, where the court said plaintiffs need to show a real threat of future harm for injunctive relief. Here, the plaintiffs had been stopped before, but Kavanaugh doubts it'll happen again, especially since many are now legal residents. He concludes the government has a fair prospect of winning on Fourth Amendment grounds because ethnicity and location can be factors under Brignani-Ponce. And irreparable harm? Without these stops, he says, enforcement would crumble, harming national security. But here's the rub. Brignani-Ponce was about border patrols, not urban sweeps in cities like LA, 100 miles from the border. Kavanaugh extends it, emphasizing probabilities like the 10% undocumented rate as justification. Professor Rory Little, in his SCOTUS blog piece titled Roving Patrols, Reasonable Suspicion and Perdomo, calls this a probabilistic shift away from individualized suspicion. This is classic ends justify the means rationale and classic government endorsing or rubber stamping government, other agency government action. Now contrast this with what Justice Sotomayor's dissent had to say. She blasts the majority for expanding Brignani-Ponce beyond recognition and doing it on the shadow docket. And again, I want to reiterate, much like I hardly ever agree with a court decision out of California, I almost never agree with Justice Sotomayor. So this is an unusual case and one I think is worth noting, even though it's just one that's been decided on the shadow docket and one that's not even reached a full decision from the Intermediate Court of Appeals or the Supreme Court. But she reminds us that Brignani-Ponce prohibited stops based solely on Mexican ancestry near the border, calling it unconstitutional. Here, she says, the district court found ICE was using race, language, and location as proxies for suspicion, leading to mass detentions of innocent Latinos. Sotomayor warns this green lights discrimination, violating not just the Fourth Amendment, but equal protection under the Fifth Amendment. She quotes stats from the case. In one sweep, 90% of those detained were legal. She argues the injunction was narrowly tailored to stop unconstitutional practices, and the government didn't prove irreparable harm. ICE can still use other factors for suspicion. But her bigger point is procedural. The shadow docket shouldn't decide novel and important questions like this one. The court's haste is especially troubling, she writes, when it comes to issues of race and immigration. She cites recent shadow docket abuses like in abortion cases and calls for more transparency. This dissent echoes broader critiques like those from Professor Little. As he notes, shadow docket rulings lack the rigor of merits cases, yet they set de facto precedents. And to Perdomo, it lets ICE resume operations without full debate. Speaking of haste, let's talk about the court's selective speed. The government filed for a stay on August 7th, 2025, and the Supreme Court granted it on September 8th, just over a month. That's lightning fast for the Supreme Court, especially on the shadow docket. Now compare that to Second Amendment cases. Post-Bruin in 2022, which struck down New York's carry laws and set a history and tradition test for gun regulations, we've seen a flood of challenges, including those against assault weapons bans in Illinois and California, sensitive place restrictions in New York and New Jersey, ghost gun rules, and more. Petitions for certiorari have piled up, some for over a year, without any action from the Supreme Court. Here we have clear violations of the Constitution and the Second Amendment, clear violations of individual liberty, and the Supreme Court has taken no action. Take Antonyuk versus James, for instance, challenging New York's post-Bruin carry bans in places like parks and churches. The Second Circuit upheld it in December 2024. A petition filed in March 2025, crickets from SCOTUS, the Supreme Court of the United States. For example, Illinois State Police versus Cothran on the assault weapons ban. Petitions pending since June 2025, no movement. Why this disparity? When the government wants to expand enforcement, like in Perdomo, the court jumps head over heels to let the government do what it wants. But when citizens challenge restrictions on core rights, like self-defense, the docket is slow. It suggests an institutional bias toward executive power over individual liberty. As gun owners, this should alarm us. If probabilistic suspicion justifies immigration stops, What's stopping it from justifying gun show raids or carry permit denials based on risk profiles? Professor Little, in his interview on the Reload podcast with Stephen Gutowski, highlighted this. He said an aggressive ATF could use similar logic to detain everyone at a gun show, citing stats that 10% might engage in illegal sales. Gun shows attract mostly white men, 82% of owners per surveys. Detain them all because some fraction might break the laws? That's the peril. That's the precedent. That's the rationale that the court is using in Perdomo. This brings us to the heart of the matter, the shift to probabilistic policing. As Little explains in his SCOTUS blog post, Fourth Amendment doctrine has long required individualized suspicion for so-called Terry stops, brief detentions based on reasonable, articulable facts about a specific person. And that's Terry versus Ohio from 1968, which set that standard. Officers need more than a mere hunch, but less than probable cause. In Perdomo, Kavanaugh's stats-heavy reasoning flips this, and he cites no authority, by the way. By citing the 10% undocumented rate in LA, he implies that group probabilities can justify detaining individuals. Little's gun show hypothetical nails it. If agents claim 10% of attendees skirt gun laws, could they sweep in and question all white men? It's not far-fetched. ATF has raided shows before, but under individualized suspicion. Little argues this can't be isolated to immigration. Fourth Amendment theory cannot be limited to immigration detentions alone, he writes. It could apply to protests, some might turn violent, churches, or any gathering. In the Reload podcast, Little said, moving from a probable cause standard to one based on demographics or probabilities would have far-reaching consequences. For gun owners, imagine a Biden-like administration using this to justify universal background checks or red flag laws based on risk groups, or a Trump-era ATF detaining ranges because some users might be felons. Probability erodes particularity, the Fourth Amendment bulwark against general warrants. At its core, Perdomo asks, can liberty be quantified? The founders said no. The Fourth Amendment reacted to British writs of assistance, blanket search powers. James Otis called them the worst instrument of arbitrary power. Particularity was key. Warrants must describe the place to be searched and the persons or things to be seized. Kavanaugh's approach revives a general suspicion. If 10% probability justifies a stop, what's the threshold? 5%? 1%? It invites abuse, especially against minorities. Sotomayor notes Latinos bear the brunt here, but tomorrow it could be gun owners, labeled extremists in some reports or by some administrations. Little warns, a fair probability of finding criminal violators among a large group isn't reasonable suspicion for everyone. In his hypothetical, detaining gun show attendees en masse would be troubling, yet Perdomo opens that door. Broader still, this logic could fuel mass surveillance. I think about NSA programs justified by terrorism statistics or COVID-era lockdowns based on infection rates. When numbers trump individuals, liberty becomes conditional, not inherent to our humanity. As gun rights advocates know from Bruin, history matters. No tradition supports probabilistic detentions. The framers fought for individual liberty against collective control. Looking ahead, the Supreme Court will soon hear oral arguments in a major tariff case, likely the U.S. versus. Looking ahead, the Supreme Court will hear oral arguments in a major tariff case challenging the tariffs imposed by President Trump, testing his executive powers. That's set in November, early November this year, so just a little less than a month away. And it challenges whether or not he can impose tariffs for national security purposes without congressional authorization. And this will be a bit of a litmus test, much like the Perdomo case. In Perdomo, they deferred to executive immigration power, and they did so swiftly. Contrast that, like I said earlier, with their approach to individual liberty, where they've slow-rolled and denied or ignored petitions for certiorari. Will they show the same deference to tariffs? It's yet to be seen, but I can't think of any constitutional rationale for executive imposition of tariffs like those imposed by this administration. And I think it will be another test for the Supreme Court on their willingness to rein in unconstitutional executive authority. For liberty lovers, these are concerning cases, among many others, but they are not good signals about the court's approach to individual liberty and the limits of executive authority going forward. I hope the court makes the correct decisions in the tariff case, but I have very little confidence in the court, frankly. But I hope that I'm wrong. So anyway, I will in the next few weeks be recording a podcast about tariffs and about that upcoming oral argument. And of course, we'll cover that oral argument once it happens in November. But like I said, the takeaway from this is that the Perdomo case is not just an immigration footnote. Even if you agree that we should take considerable efforts to make sure that people are here lawfully, we shouldn't do so by eroding the foundational protections of our individual liberty, including individualized suspicion for stops, the Fourth Amendment, the Fifth Amendment, and the right to be free from unreasonable searches and seizures. Perdomo is a warning about how probability can pervert justice. This sort of probabilistic policing threatens individualized liberty. It has the potential to threaten gun owners, and today's roving patrols in LA could be tomorrow's ATF sweeps at your local gun show. As always, I hope you enjoyed the show. If you did, don't forget to subscribe and give us a thumbs up and a review. The reviews really help us with the algorithm to help reach new listeners like you. Like I said at the beginning, freedom is about vigilance. Thanks for listening. And as always, you can find us on all the most popular podcast streaming platforms. You can also find us on YouTube, Rumble, Facebook, and X at Forge of Freedom and at forgeoffreedom.com. Until next time, remember, you are the Forge of Freedom.